Okay, so we're gonna get started. I just wanted to introduce our moderator, Ashley Parrish, who is a partner at King & Spalding, where he leads the firm's appellate and strategic counseling practice group. He's been actively litigating all the issues that we are discussing here today. He also somehow, in the midst of private practice, has time to write academic articles. He has a great article with Mike Grieva on administrative law without Congress that I would recommend to you. So with that, I'll turn it over to Ashley.
Thank you very much, Naomi, and thank you all for coming to this panel. This panel is titled Separation of Powers, Congress, Agencies, and the Court. I think it's a very timely topic to be addressed. It seems that when you look around, all the institutional dynamics and separation of powers are somehow out of whack. We have Congress that doesn't really seem to be able to legislate. We have executive agencies that seem very capable of legislating, and we have courts that don't seem to know quite what to do with it all. We have a wonderful panel of 4 speakers that will address that. I'm going to very briefly introduce each of them to you. To my immediate right here, we have Chris Walker. He's a professor at Ohio State University College of Law. He has written a really fantastic paper and an empirical study titled Legislating in the Shadows, which I hope he's going to say a few words about today because it's really an important contribution and something worth taking a look at. Next to Chris is Naomi Rao, our host today, and what a wonderful conference she's put on for us. She's a professor here at GMU, also the director of their administrative, or Center for the Study of the Administrative State. She has also written a paper last year that talks about delegation issues, which I had a chance to read in advance of this panel, which I hope she will also talk about because it's really quite fantastic and I think contributes a lot to our discussion. After that, to her right is Will Levy, who's the Chief Counsel for the Senate Judiciary Committee. He's going to offer us some thoughts on legislation that's being considered right now, as well as some of the other issues that are percolating around more from the legislative side. And then lastly, at the end of the table, Boyden Gray, whose credentials are really too many to summarize, but he's an ambassador, the founding partner of his own law firm, and of course a former White House counsel. My role today is to get out of their way, but just so they know, each speaker is going to be rigorously forced to an 8 to 10 minute limit, and then I will cut them off. We will then have a discussion among the panelists for some time and then open it up for questions from the audience. And with that, let me thank you for coming, and I'll pass it to you, Chris.
So because this is a panel on Congress and agencies, before I talk a little bit about the legislating in the shadows and the mysterious role that agencies play in providing technical drafting assistance, I wanted to throw up onto the board, as part of our discussion, the Separation of Powers Restoration Act. It is a very simple, though drastic change perhaps, although I think Aditya Banzai would say it is just restoring the original meaning of Section 706. But what it would do if it were ever enacted, which it never will, but you're saying it well, okay, well, I'll leave that to you.
I'm agreeing with you.
Is that it would strip the courts of Chevron and our deference. In other words, it would say, all right, we really meant that courts decide these questions de novo, and it expressly says with respect to statutory provisions and rules. And I think that this is interesting, and I want this to be in the backdrop of our discussion today on what can Congress do, what is Congress's role in the modern administrative state, especially with respect to judicial deference regimes. And I also want to start, Dan Farber, I feel like I placed the question there that he ended the last session with, of saying, I'm not really sure that Chevron even matters. And I want to pause before I get to why it matters in other ways, to kind of say, this is based in part on a study, in fact, in large part on a study by Bill Eskridge and Lauren Baer that looked at 1,000 Supreme Court decisions dealing with agency statutory interpretations. And at the end of that, they concluded that, you know what, the win rate is basically the same. In fact, it's actually worse, according to some subsequent studies, at the Supreme Court when Chevron applies and when it doesn't. And so therefore, Chevron doesn't matter. And I think the Supreme Court's the wrong way to look at this. And I just finished running some data on the Courts of Appeals. A co-author, Kent Barnett and I at Georgia, just looked at 10 years of data in the Courts of Appeals, about 1,500 different cases. And the results are very different there. Circuit courts in those cases, and these are cases where they mention Chevron or one of the circuit precedents that are similar to Chevron, They apply it 75% of the cases. There's an agency statutory interpretation. And when they apply it, the agency wins 77% of the time. When they don't apply it, the agency wins 53% of the time. Now, there's some methodological limitations. There's a number of different arguments on why that number might be overstated or understated, the difference. But it's a pretty big difference, almost 25 percentage points. If you want to kind of dig into a little bit deeper, no regime, Skidmore, and de novo. And I mentioned no regime, and that's actually a lot of circuit courts, unlike the Supreme Court, will say, we don't have to decide whether Chevron applies because they win under any standard, or we don't have to decide because they lose under any standard. So I would say, if we're thinking about whether Chevron matters, like Congress's efforts to get rid of Chevron and our deference, or courts' efforts to chip away at it, I think the wrong focus is the Supreme Court. A more proper judicial focus is the courts of appeals, where most of these cases are decided, where they hear at least 150 cases a year dealing with Chevron deference. The second point I want to make is a different empirical study I did a couple of years ago, where I actually went and surveyed agency rule drafters about what they do, what rules they think about when they're interpreting statutes and drafting regulations. And I asked them, and this is based on a terrific study by Lisa Bressman and Abby Gluck of Congress, and I asked them very similar questions of which canons matter? What do you use when you interpret a statute? And the number one winner is Chevron. 90% of rule drafters surveyed, these are 128 rule drafters at 7 executive departments, 2 independent agencies, concluded that Chevron, this is the big winner. This is what they think about, the most of them think about along those lines. And what does that mean? I asked a couple more questions, and this is a messy graph, and I probably shouldn't have used this. But what do you mean by you use Chevron? And what they said is they know that they have a better chance of winning, vast majority, if they have Chevron instead of Skidmore. They know that judicial review affects the way that agencies draft. And then it's a little bit less strong evidence, but 2 and 5 said that they agree or strongly agree that their agency is more aggressive when they know Chevron applies in their interpretive efforts. And another 2 and 5 said they somewhat agree. Pretty candid that at least a plurality of these agency rule drafters that have been at these agencies for years would say, yeah, when our agency is confident Chevron applies, we're going to be more aggressive. We're going to push the pocket a little bit more than we would if it didn't. So I do think Chevron matters. It matters in the courts of appeals, and it matters in how agencies function and how aggressive they are in fulfilling their statutory mandates. Now, I want to talk a little bit about legislating in the shadows, which is the paper that's posted on the conference website. When I say legislating in the shadows, it's not quite this mysterious. So what I mean by that is agencies you can group the way the agencies, their role with Congress and legislative drafting in 2 big camps. One is substantive drafting. It doesn't happen a lot under the Obama administration, but in prior administrations, agencies would draft statutes. They would go through White House review and then would be introduced in Congress as an agency or administration-initiated legislation. Agencies also provide formal official policy statements on statutes. So does the White House, and all of that goes through White House review. I'm not talking about that with this project. I'm talking about the other type of legislative activities that agencies play, which is called technical drafting assistance. I'm saying legislating in the shadows because it sounds a little bit better in technical drafting assistance. At least it'll get law review editors more excited about the piece. But what I mean is this is what happens at the beginning of the process when a congressional staffer, oftentimes before the legislation is even introduced, sometimes before it's even sent to their boss, asks the agency for comments on the piece of legislation. We call them technical comments. Sometimes they can be actually quite substantive. But the idea there is that the agency is able to leverage its expertise at the outset and get the legislation in the best possible shape before it starts the legislative process. Now, this will continue throughout the legislative process. Agencies continue to play a role in providing technical drafting assistance all the way through enactment. And what I had done is the Administrative Conference of the United States commissioned a project on this to understand what are the best practices, how involved are agencies, are there ways to better leverage the agency's role. And as part of that project, They did interviews at about 20 or so agencies, and then 10 of them agreed to be like official case studies. And we wrote up reports on how all 10 of these agencies, how they do their technical drafting assistance, what challenges they have, and the like. And then we followed that up with an anonymous 40-question survey to kind of drill. We thought there were some common themes that were coming out in the coding of the interviews to get a better sense of whether those are the challenges, the best practices, and the like. And what you find from a process point of view is it's a pretty typical process. Congressional staffer comes at the beginning. The agency then usually gets that through the political side of the agency, through legislative affairs staff. And then the lawyers and the policy experts get to work. And they provide this technical drafting assistance. Oftentimes it's by phone, but usually it's also in writing. You might think of this as like a track change version. And they're heavily involved. Now, some of the interesting findings about this is that the agency officials reported that they provide technical drafting assistance on just about every piece of legislation that directly affects them that's ultimately enacted. That their rate of providing assistance, the rate of Congress coming to them is really quite high. Another thing that was interesting to me is that they seldom refuse to provide assistance, even if it's legislation that they would frustrate the mission of the agency. Their goal is to try to provide as much assistance as they can in order to, well, a number of different things. We can talk about that more in the Q&A if that interests people. But they don't, it doesn't matter if it's from the minority or majority party or from the president's party, they're going to provide this technical drafting assistance. And then just kind of three other key points here. I already mentioned that, oftentimes they write in orally before legislation is enacted. It's a very informal process where they also provide substantive feedback. And then lastly, and this ties into Chevron, you think, well, why are we talking about this with Chevron? Is that one of the general themes that emerged during the interviews was that this idea that the agency's goal was trying to have the legislation do no harm. In other words, trying to preserve their regulatory authority. Some people would say regulatory flexibility, try to keep the draft legislation as broad as possible. In other words, although they didn't quite come out and say this, we try to make sure the legislation is ambiguous as possible so that we have the authority to come back on the back end. And that's really where the paper goes. And Judge Kavanaugh set me up really well for this, in the sense that there are kind of three different arguments you could draw from this. The first is Chevron deference rules, because look, these agencies are involved in the legislative process from the get-go. They're the people who know the legislation best outside of the actual staffers, member of Congress that passed it, drafted and enacted it. And so they should be given deference because they know that. A flip side is you might look at the Auer decisions that Judge Kavanaugh mentioned at lunch and say, this might seem contrary to fundamental principles of separation of powers to permit the person who promulgates the law to interpret it as well. Here, it's a little step removed, but the argument is that, similar to what Justice Scalia would say, that the agency has this desire, when it's helping Congress at the get-go, to enlarge its own regulatory authority. In other words, because it is involved at the beginning, and Naomi is going to build on this more with her terrific article on how there's administrative collusion between agencies. I assume that's what you're doing, right? That's another reason why. So in other words, because they are involved, because it's in a confidential process in the shadows at the beginning, we might not want to set the interpreted default as Chevron deference. And then the third one is the Kathy Sharkey first model, the King v. Burwell model. So maybe you don't get rid of Chevron entirely, and I say replace it with Skidmore under option 2. Maybe under option 3, the answer is that instead you do what the chief did in his dissent in the city of Arlington and what he did for the majority in King v. Burwell, and you ask, do we really think that the agency, the Congress, the collective Congress meant to delegate this authority to the agency or not? Do we think that this is the type of thing that they intentionally delegated? Or do we think that this is inadvertence or worse, collusion at the beginning between one member of Congress and administrative agency? And that would be another way to kind of check the potentially perverse incentives for agencies to use the technical drafting process to give themselves more power than the collective Congress would have intended them to. So I think with that, I'll sit down.
Great. Thanks very much for that, Chris. I'm going to continue with this theme of discussing the relationship between Congress and the agencies in the context of judicial deference. So it's understandable that a lot of analysis of judicial deference focuses almost exclusively on the courts, or at least the trade-off between courts and agencies. But it seems to me that the real root of the problem of judicial deference starts with Congress. And so while we are rethinking judicial deference, we also have to consider the role of the first branch of government in creating this problem. So as we're all quite familiar, the foundation of the modern administrative state is that Congress delegates often very significant and open-ended authority to agencies. Agencies often then make rules that are really, I think it's fair to say, much more than gap-filling. They're really for all functional purposes, making law through regulation. And then when such actions are challenged in court, the underlying statutory authority is often so wide open that there's very little law to apply. How can a court properly evaluate whether an agency policy is lawful when it's faced with only the broadest outlines in a statute? This relates to some of Judge Kavanaugh's comments at lunch, right? I mean, how do you know when a law is even ambiguous, right? How do you get to some sort of agreement between judges on how to interpret statutes? But I think when judges are faced with these quite open delegations, they've had a tendency to defer to reasonable agency policies, and they've done so based on a variety of justifications. In particular, they've relied on agency expertise, and they often also talk about the political accountability of agencies through the president. What I want to focus on, though, is another rationale for deference that is often overlooked. And it's a rationale that was sometimes offered by Justice Scalia, who at least for many years, maybe up until his passing, was one of the staunchest defenders of Chevron. And one reason he offered for this was that, he took a kind of simple idea that Congress, when it delegates to the agencies, just gives up its power, right? It's a very simple transfer of power to agencies. And he wrote in the Decker case in 2013, he said, quote, "Congress cannot enlarge its own power through Chevron. Whatever it leaves vague in the statute will be worked out by someone else." So there he's really explaining that when the courts defer, they're not aggrandizing Congress or members of Congress. They're just leaving interpretive power with the agencies, which is where Congress placed it. And so there's an assumption, and it's usually implicit in a lot of the deference cases, that when Congress delegates, there's just this simple transfer of power from executive agencies, and also kind of in the background of that, this idea that the political branches will continue to compete over the exercise of lawmaking power. I think, however, that when Congress delegates, the exercise of government power turns out to be much more complex than that simple story. So first, individual members of Congress can realize a number of benefits from delegation. Some of these are quite familiar to us, right? When they delegate, maybe they can avoid responsibility for difficult choices, or they may find it easier to pass legislation because they have to agree on fewer details in the statute. But I think, as Chris mentioned, right, that delegation often creates what I've called administrative collusion. And that is a situation where delegation, we quite obviously see, expands the power of agencies, right? Congress is giving power to the agencies and expanding the scope of their regulatory power. But individual members also have a chance to benefit because they can influence the discretion that's placed in the agency. And the individual members can do this through a variety of mechanisms. Some of them are formal, such as oversight hearings or the appropriations process. But they also have a number of informal ways of influencing administration, through the back door when members or their staff are working with agencies to influence how they exercise their delegated authority. And the collusion, in some ways, by definition, really goes both ways, right? Congress is influencing agencies, and as Chris's paper discusses, agencies are often the chief movers behind the drafting of statutes. And what happens when courts defer to agency decision-making, they're often ratifying this collusion between members of Congress and agencies. And so deference is really compounding the problem of collusion between the branches. And so this collusion and deference raises to me, a number of serious separation of powers concerns. Right? First, the Constitution vests all legislative power in Congress. And this has always been understood to contain a non-delegation principle. We're all familiar with the idea that the court rarely enforces the non-delegation doctrine, but in all of the non-delegation cases, the court repeatedly reaffirms that non-delegation is a core part of Republican government, and that lawmaking has to be done by the people's representatives, not by unaccountable administrators. But of course, delegation allows, at least functionally, for a significant amount of lawmaking to occur outside of Congress. Another problem is that the Constitution gives members of Congress no executive power whatsoever. And in fact, the Constitution, both the text and structure, are very carefully designed to prevent members of Congress from exercising executive power. Just to take one example, there's the incompatibility clause, which prevents members from simultaneously serving as executive officers. And then just as the Congress has no executive power, the executive has no legislative power. This was a lesson articulated in the famous Youngstown Steel case. The executive can implement the laws passed by Congress, or they can implement the powers given directly to the president by the Constitution, but the executive has no inherent lawmaking power. So delegation really promotes this kind of collusion between the branches, right? Both branches can benefit from delegation, and both political branches can exercise greater governmental power through these open-ended delegations. And this leads to a fairly dangerous combination of powers, contrary to our constitutional structure. But another problem that I also think occurs through this dynamic is the diminishment of Congress as an institution. I've mentioned that delegation can benefit individual members of Congress, but wide-scale delegation has shifted significant powers to agencies and away from Congress as a whole. And because of the existence of so many of these delegations now, it becomes more and more difficult for Congress to effectively legislate on regulatory matters. For instance, if they want to overturn a regulation, they're going to face a lot of difficulty, right? They have to go through bicameralism and presentment. And if the regulation is based on a favored presidential policy, well, then they can expect a presidential veto. And so once the authority has been delegated, the executive really has all of the procedural advantages over Congress, right? It makes it very hard for Congress to act. I also think delegation unravels an essential component of Congress's structure. Congress is a collective multi-member body, and really our legislature is the primary mechanism for Republican representative government, right? It's the way we have for bringing all the disparate interests of our society together into one place, and we hope that they will work together to enact laws for the public good. And we expect that our senators and representatives have their own particular sets of interests and ambitions, but what the Constitution does is it gives them really only one primary power, which is to act collectively to pass laws. And this structure has a very important purpose, right? In addition to serving Republican ideals, is that it aligns the interests of the individual lawmaker with the institution of Congress, right? When James Madison talks about ambition counteracting ambition, it's kind of hard to figure out what is the ambition of Congress, right? How do we understand what their ambition is? And their ambition really has to be a collective one, right? The individual lawmakers are given no power on their own. But what delegation does is it unravels this structure, right? It unravels the structure that makes Congress come together as an institution, because it gives individual members a way to realize their ambitions and their interests outside of the lawmaking process. And if that occurs, right, members may well focus much more on what's going on in the agencies rather than working to pass legislation. And maybe this dynamic provides some explanation for some of the dysfunction we see in Congress. But I think it's a sort of vicious downward spiral, right? Delegation shifts power away from Congress, and that creates incentives for lawmakers to focus more on administration, to delegate away more power, and that spiral continues. And so I think this problem of collusion between the political branches is pervasive, and I think it's serious, and it really unravels the way our separation of powers was designed to work. So just to conclude and return to our theme, administrative collusion undermines one of the core justifications for judicial deference. Right? Deference does not simply allow Congress to give up its power. Instead, it allows members of Congress and the agencies to work together to expand power outside the checks and balances of the Constitution. And courts, in some sense, really compound this problem of collusion when they defer to agencies. And this provides just another reason for rethinking the judicial deference doctrines. Thank you very much.
Good afternoon. Thanks for having me. I'm able to be with you today because I work for a senator who works for an absentee Congress. This week is recess week. It's one of 22 recess weeks this year. And this means the Senate will only be in session for approximately 30 weeks in 2016. And get this, our work week is only 3 days long. So remember when James Madison wrote in Federalist 48 that the legislative department is everywhere, extending the sphere of its influence and drawing all power into its impetuous vortex? Well, no one would recognize today's Congress based on Madison's description. And instead, Congress has invested in its own irrelevance. And it has shirked responsibilities, and it has permitted, and it indeed even encourages the executive branch to do work that the Constitution assigned to the legislature. So in response to this, the senator I work for, Senator Mike Lee, has launched what he calls the Article 1 project. This project seeks to revive and re-empower Congress on the theory that the stability and moral legitimacy of America's founding institutions, governing institutions, depend on a representative, transparent, and accountable Congress. And as you saw on one of the slides here a moment ago, reforming Chevron deference was the project's first target. And of course, Chevron is fair game for Congress to abrogate or to otherwise modify because it's just a judge-made doctrine of deference premised upon Congress's presumed intent to allocate responsibility with the agencies and not with the courts. It's just a background rule against which Congress can legislate. So, and indeed, Chevron itself did not even purport to be based on a statutory interpretation of the Administrative Procedure Act. And for good reason, right? For those of you, and I assume all, who have read Section 706, the Act directs the courts, not the agencies, to decide all relevant questions of law, interpret constitutional and statutory provisions, and determine the meaning or applicability of the terms of an agency action. So I won't bore you with an additional description of the Separation of Powers Act. Suffice it to say that it seeks to make even more explicit what some of us think Section 706 already said when it was passed. I'll note also that this is surely not the only solution to the problem of administrative overreach, but Chevron exacerbates the delegation that has so undermined the separation of powers. When Congress delegates its authority away to administrative agencies, it gets to take credit for doing something by virtue of having passed a generally worded, vague enactment. And at the same time, it gets to avoid responsibility for any controversial actions that the agency may take. And judicial deference to agency action plays a key part in this by permitting Congress to delegate and then blame the agencies for what the agencies do with that authority. But judicial review, our view of statutes, points the finger back at Congress and has the potential to force Congress to accept responsibility for agency action by taking a side, either by doing nothing or by being forced to act. I'd like to move away from the Separation of Powers Restoration Act, if I might, and address some of the points that Chris made in his article, which I think is right. and I think he is right in part for reasons that he doesn't identify as well. Every year, experts and other personnel from departments or agencies of the executive branch are detailed or assigned to congressional committees. Indeed, in the 113th Congress, which is a Congress spanning the period of time from January of 2013 to January of 2015, there were 190 executive branch details who were approved to work on Senate committees alone. I don't know how many were assigned to the House. I imagine more. These assignments included details from HHS to work on the Health, Education, Labor, and Pensions Committee, from the Department of Agriculture to work on the Agriculture Committee, from the Department of Justice to work on the Judiciary Committee. You get the idea. And details serve in a variety of roles, but one of these roles is legislative drafter. And before I go further, I should disclose that I am a direct beneficiary of this practice. I have had two very able details work with me, and I am about to hire a third next week. But I think this practice may be additional evidence of the pathology of legislative surrender and provide additional reason to question the continued efficacy of Chevron. The Office of Legal Counsel actually has twice addressed the legality of details, once in 1977, once in 1988. In 88, OLC was of the view that details do raise separation of powers concerns because they place the employee in the difficult position of serving two masters with conflicting interests, the legislative and executive branches. OLC concluded then that among other reasons, details do not violate the separation of powers as long as they are advisory in nature. But OLC also found that even when confined to this advisory function, and I'm going to read this section because it's illuminating, details of executive branch employees to the legislative branch raise substantial separation of powers concerns. In our system of separated powers, the legislative and executive branches often have conflicting interests, and thus a detailed employee may be put in the difficult position of choosing between serving the interests of the executive branch and those of the legislative branch. For instance, one DEA agent has been detailed to aid in the evaluation of DEA programs, presumably with a view toward legislation. This surely exacerbates the well-known tension between the executive branch's interest in having administrative flexibility and the legislative branch's interest in imposing more detailed requirements on such management. So, OLC was a little unclear whether this would injure Article 1 or injure Article 2. But in 1988, OLC was of the view that it is doubtful a detail can faithfully defend the interests of the executive branch when the detail has been specifically detailed to do the legislative branch's bidding. But in 1977, OLC took the exactly opposite view, and they reasoned then that if a detail would continue to be paid by the Department of Justice, would expect to return to the Department of Justice at the conclusion of the detail, then they would likely to seek to advance the position of the Department of Justice while working for the Congress. So whichever view is ultimately correct in the individual case, the practice of executive branch details, in my view, provides additional reason to question the assumption that the Congress and the President compete for control over lawmaking. If the fourth branch is in fact a fifth column, the problem is even worse than we thought. And this, of course, as two of our panelists have already discussed, may have implications for Chevron. First, Chevron represents, as I said, a presumption about who, as between the executive and the judiciary, should resolve statutory ambiguity. As Justice Scalia has noted, and I'm sure it has been quoted already during the conference, the executive, the competing political branch to the legislative branch, is the less congenial repository of the power as far as Congress is concerned. So Congress's incentive is to speak as clearly as possible on the matters it regards as important. Under this view, it is assumed that Chevron will incentivize Congress to delegate less and legislate more clearly because of institutional political rivalry. But this assumption is incomplete, not just because Congress itself has an interest in avoiding accountability, and for some of the reasons that Naomi articulated, but also because the actual drafters of the laws in certain circumstances are executive branch employees themselves who may not fully share the legislative branch's interest in imposing more detailed requirements on the executive branch. So in this way, judicial deference would not enhance, but would instead undermine separation of powers by not just promoting broad delegations in drafting, but also incentivizing the executive branch's conquest of Congress. I'll make one very brief final point to connect to Chris's great article. As Chris has noted in his article, at last term, Justices Scalia and Thomas called for overruling Seminole Rock or our deference on the theory that lawmaking and law interpretation cannot reside in the same hands. This would give the agency the power to write ambiguous regulations and then be the judge of what the ambiguity means. But this combination of lawmaking and law interpretation may also be apparent when agencies interpret their statutory mandates if representatives from those agencies have strongly influenced the actual drafting of the statutory mandates themselves. So here, too, the agency might have some control over the promulgation of the statute in the first instance and then be the judge of any vagueness or imprecision that they've built into the statute. And so, as Chris discusses quite persuasively in his article, the perverse incentives that Scalia identifies with respect to judicial deference to agency interpretations of its own regulations may be present as well in the legislative process. Thanks.
Well, thank you, Naomi and George Mason family for this opportunity. It's a great conference and a great lineup of people, and it's been a real pleasure to participate. I'm reminded in all this discussion about ambiguity and is it clear and when is it not clear, and it's all in the eye of the beholder, legislative history. Spare me just sort of one story. I was properly listed as having been ambassador to the EU, and when I was there, I lived in a residence, some people have heard this, and I'm sorry to repeat myself, which had the most sophisticated safety equipment because it had been originally built by a Russian oligarch who feared for his life and was such a bad guy, he actually ended up never getting a visa to go to Belgium, so the State Department bought the house instead, and the centerpiece were very thick doors surrounding my bedroom, which my Flemish security experts told me were the top of the line, 4th century doors. And it took me 2 full briefings to gather up enough courage to ask, what is a 4th century door? I mean, why not a 5th century door or a 3rd century door, or maybe even better, a 21st century door? And I was told that a 4th century door is that door which, for 1/2 hour to allow you to call the police if you're under attack from ISIS, can withstand anything that can be thrown at it in the 4th century. So you have images of the battering ram and the boiling oil and, whatever. I would tell this, and I had to do a lot of after-dinner speaking, and when people had a lot more to drink than you have, and it was, made people laugh, and it got me through. In fact, the only thing I'm remembered for is this story. And one day my publicity person, PR person, came up to me and said, Mr. Ambassador, you've got to stop telling the story about the 4th century door. And I said, why? He said, because there isn't such a thing. You're gonna heap disgrace upon yourself, your mission, and your country. And I said, but I've been twice briefed by these Flemish, really careful security people about the 4th century door, and he said, well, they're wrong. There is no such thing as a 4th century door. And I said, well, if I don't have a 4th century door, what is it? And he said, what you have is not a 4th century door, but a forced entry door. So you can see why we have so much difficulty with statutory interpretation. I'm glad to have happy to participate in a panel that puts a little bit more focus, as my predecessors up here have done, on the Congress, because I think that's where the problem starts. Deference is really an outgrowth of, in large part, not exclusively, large part, overbroad grants of authority, overly vague grants of authority, where the absences, the holes, the gaps, the lack of attention to detail in drafting has left open the ability to look for ambiguity and aggrandize power. And of course, agencies coming in and helping write the statutes in the beginning is endemic. And my favorite example is CAFE standards that were parallel rules, one written under a congressionally authorized, specifically authorized statute passed under President Bush and promulgated or implemented by President Obama, and the other was under the Clean Air Act for EPA. So you had NHTSA or DOT and EPA issuing parallel rules, and EPA had people swarming all over the Hill during the passage of the act in 2007, making sure that nothing in the act or its legislative history or in any other way would impinge on any potential authority that EPA might assert, however tenuous, to control the exact same, address this exact same problem. And so you have these parallel rules that just simply do not fit and causing great trouble, sort of making you wonder whether Stevens was right to say EPA, DOT is all the same, and Massachusetts EPA doesn't matter. Well, it does matter. And I think that is a problem, too much broad delegation. And so what is the answer? I'm in favor of the statute that says that the appellate review sections of the APA mean what the appellate review sections of the APA say. But I really think Congress has got to step up and do more. They've got to go back and do the kind of detailed statutory work that they just don't do now. Maybe it's because of the short work week, the provision of money to take trips back and forth to one's hometown, the fact that a lot of families don't move here now, so there's no weekend camaraderie. There are all kinds of these things people read about, and it's all true. And so Congress really is not doing what it should be doing, and the ambiguities that now exist, I really swear, although I've not done the study, did not exist in the same scope when I first came to Washington, 35 or 40 years ago. And if you look at the 1990 Clean Air Act and look at all the detail, Congressman Dingell never would have delegated to EPA the right to decide how many milligrams of this or what could come out of the tailpipe. No, he told the EPA what the answer was. EPA didn't like it, but that's the way Dingell was. But that doesn't happen anymore, and it should. Part of the problem, no doubt, is so one way of answering that particular problem is for the courts simply to be a little stricter on the non-delegation doctrine. It's not just a canon of interpretation. I mean, it doesn't have to be just a canon. Maybe the courts ought to throw out a couple of statutes for being too open-ended. One of the interesting things that Justice Scalia was clearly rethinking, as you've heard earlier, was, perhaps we are delegating too much. And originally, I think his view was, if Congress wants to give away its power, I mean, who are we in the courts to stop them? But I think he was rethinking that. And in the American trucking case, very interesting, where he makes the point very, very clearly, if there's a non-delegation allegation, the canon of judicial deference, Chevron, does not apply. Now, most people have sort of lost track of this, but it isn't just a big issue as King versus Burwell or Brandon Williamson. He's saying if you have an allegation of an overly broad delegation, Chevron does not apply. So just remember that. I think that's very, very important. I think if he had lived, we would have seen more attention to the scope of delegation. I sometimes ask people, young people coming just out of law school, even coming out of the Hill, have you ever heard of an amendment in the third degree? And they have no idea what I'm talking about, an amendment in the third degree. An amendment in the third degree, when I first came here, you had to know that very, very well, because that's an amendment to an amendment to an amendment, which is verboten. But no one deals now with an amendment to an amendment, let alone an amendment to an amendment to an amendment, because it's all done, we got to enact it to find out what we put into it, as Pelosi famously said about Dodd-Frank. So I think the non-delegation doctrine really ought to be remembered as a very important tool I don't think we'd have so much of a deference problem, and we didn't when I first came to Washington, in part because the statutes were much more specific, limited, and detailed. Another thing that I think should happen is there should be more disclosure of what the Congress does in connection with agency interpretation. Long ago, at the beginning of White House review under Executive Order 2291, 13866, it was obvious that private sector special interests would have to have made public their visits to EPA or FDA or whatever, FCC, and that, or OMB, the Office of Information Regulatory Affairs, the Nerve Center, those visits have to be logged too. So everybody knows who's going in to see the executive branch to try to influence the way a rule is written, but not Congress. And so Congress is the one way around, it's a way to launder your visits to the agencies, because you do it through a congressperson. And I once proposed, when I was White House counsel, one of the biggest mistakes I ever made in terms of my internal relationship in the West Wing, that all contacts by Congress with OMB and with the agencies be logged just like the private sector. Well, it was about 30 seconds before Vice President Quayle was in my office, former Senator Congressman, saying, "You're going to be fired if you continue to press this outrageous suggestion." And but I do think that that would solve a lot of the problems if there were transparency as to what was actually going on. Obviously, there are incentives, as Naomi said, for congressmen and senators to leave things vague so that they can go back in and trade a fix for it, for a little campaign donation here, a little help here, a little PAC there. And believe me, that happens. And it's not a good situation. More disclosure would, I think, reveal that what we have is a kind of ongoing legislative veto where Congress is not quite letting go and making a lot out of the gaps that they should not have created or let survive in the first place. So I will stop there. I think Congress is the source of this. Just to emphasize, it's the source of this. We wouldn't have half the delegation problem we have now if Congress were doing a better job of tending to its own business. Thank you.
So what we'll do is we'll progress now to the sort of discussion part. I have a few questions for the panelists. Let me just first say I wasn't here for all the panels this morning, but I think we should all thank Boyden for elevating the level of humor on this panel, and we send that as a challenge to future panels. Listening to everything folks have saying, I just want to pose a question, because I think some of the thoughts from this panel are really quite in contrast to some of the panels we heard this morning. And here's a question for you, which is, why shouldn't courts just be more willing, not so much just on non-delegation grounds in the sense of overbroad delegations, but just more broadly be willing to say no, and just say to the agencies that when it's clear that an agency is trying to expand its authority or is interpreting a statute in an aggressive way, that the right posture should just be to say, no, you cannot do that, and that Congress will now be required to speak more clearly. Not on policy grounds, but simply that the statute is not clear enough. But there is clarity, there's a range of it, but it is always possible for Congress to speak more clearly, and they can easily come back. Wouldn't that solve both, Chris, your problems? Because once you know that the agencies are actually providing technical drafting assistance, they should be in a good position to help the Congress speak more clearly. Naomi, address your problems, and then also, I think, go to what Boyden is talking about, but perhaps in a slightly different way, because it wouldn't be striking the statute down. It would just be telling the agency that the existing statute doesn't let them do what they want. So I throw that open to the panel.
Well, I guess I kind of don't understand. So it's basically what we're all saying you should do, right? Get rid of Chevron, and I mean, if that's the option, either get rid of it wholesale or do the Roberts really take a look at the delegation issue and determine whether.
Yeah,
or is what's different?
I think it's separate from Chevron, because if you take a look at what Roberts has done, he still tries to interpret what the statute requires, and he's willing to interpret it broadly. So Burwell is a good case. perfect example of this, which is that hold aside whether you like what Congress is doing one way or the other. There would have been a very good argument there to just say, we have no clue what Congress wants. Congress, go ahead and tell us. And we're not going to decide that, which is what the chief ended up having to do, which was interpret the language in a way that, you know, arguably was right, arguably was wrong, but he had to interpret a very difficult question. It would have been outside of Chevron. It wouldn't have been a major questions doctrine so much as just a
So
sort
you're
of
like remand it to Congress? Is that the idea?
Yeah. No, you'd have to have
But
some.
does the agency action disappear then? I mean, does that invalidate their action or no?
You just don't let them do it. I mean,
Right.
you know, you'd have to have some logical distinctions as to where it would apply, and maybe it doesn't work because obviously the run-of-the-mill cases it wouldn't. But you think about Mass v. EPA, another big agency case, where the right response there, you know, in terms of delegation things, would have just been to say, no, you can't unleash this new program until Congress tells us we don't think there's enough here for us to determine whether there was or was not a delegation, so we're just going to let Congress speak more clearly.
Yeah, I mean, I think that type of solution is really to say, right, that the agency doesn't have the authority, right? They don't have the authority to do whatever they did, and if they want that authority, they have to go back to Congress to get it. Right, which is a kind of non-delegation decision, right? That they don't have any implicit delegated authority.
But it's like
to do
a
what they've
penalty
done.
for poor drafting kind of too, right?
Right.
Right.
Yeah.
But you know,
Against
it's sort
Congress.
of like the idea of Judge Easterbrook's article from the 80s, Statutes, Domains, which is one of my favorite articles, right? The statute just doesn't say anything, right? And so there's no interpretation, it just goes away. Maybe there's something to that, because that doesn't replace the judge's view of policy with the agency's view of policy. It just says the agency has no authority.
Right. This is
Right.
too difficult. You made us a hard question, and it isn't. It is deference to Congress because Congress gets to fix it, and it's also not policy making because the court is trying very hard not to actually define what Congress did. It just can't figure it out. Anyone else on that?
My reaction would be that this is some form of what all of us in some fashion are advocating. I think one concern would be a line drawing concern. I mean, have you read a statute, right? It says the secretary shall do X, broadly worded something. The administrator shall do Y, broadly worded authority. They all say this. They include that mechanism in almost every complicated statute, almost every statute. So what you're talking about is a different kind of background assumption when evaluating most statutes. It's not the one-off statute that looks this way. This is the way that Congress legislates for a lot of the reasons the panelists have identified, because of an expertise gap. How to actually fill in the content of what the secretary might do is a task that's hard for Congress, notwithstanding some of the things that we've mentioned about how the agencies are involved. And there's also an interest gap. I mean, Congress wants to identify the high-level pitch and let the agencies fill it in because Congress isn't interested in filling it in.
Yeah, not much I can say. So I agree with with everything that's been said. I think that courts need to be a little more aggressive at the front end. I think if they were aggressive and they took away sort of the moral hazard of letting sloppiness just get sloppier and sloppier and sloppier, if they all of a sudden put an end to this moral hazard problem, it would take a couple of 3, 4, 5 years of rulings from the Supreme Court to do this. But I think it would happen, and it would stop a lot of the difficulty. And I think that if you look at Thomas's dissents, you see the kernel of some of this developing. And I don't think that those who are in the so-called liberal bloc are going to be all that hostile to this. But remember, there's been some commentary about this already. But remember that there are about 10 or 12 occasions just during the current administration where the Supreme Court has knocked down an executive overreach by a vote of 9-0, not 5-4. So I don't think anyone should be scared as litigants, and a lot of people in this room are going to be influencing future litigation, to ask the courts to come and step in and help, at least as an interim matter, reset the balance a little bit.
Another thought I had for the panel was that it strikes me that I'm very skeptical of congressional fixes, and the reason is because I think, you know, while good intention, they really can go that far. And the reason is I think there's sort of an anti-circumvention problem that cannot be fixed unless courts always at some point are willing to step in and anticipate the anti-circumvention. So Congress tomorrow can say cost-benefit analysis, and what does that mean? 10 years down the road, it means pretty much nothing unless the courts have some shared conception of what that is. And I just wondered, Will in particular, I'd be interested in your thoughts on that, but the whole panel, whether you have any idea as to how you address that problem in terms of, there seems to be so much focus these days on Congress trying to fix Chevron or other administrative law doctrines, and I'm very skeptical that any of the actual proposals will amount to much unless, like what Boyden was just saying, courts are willing to be a little more aggressive and put their foot down.
Yeah, I agree with that. I think there's sort of an internal contradiction to the idea that Congress would pass a Chevron abrogation bill, right? A Congress that is willing to pass such a bill is a Congress that is willing to legislate more clearly. And we don't have such a Congress. But we could, and the easiest and foremost fix to all of this would just be for Congress to sit down and say what it means. And in circumstances in which cost-benefit analysis starts to mean something that Congress didn't anticipate, that judges are building into it, then Congress legislates again. But we don't have such a branch, and so I think there is a problem of talking about a Chevron bill in circumstances in which Congress isn't doing the first and easier step that the Chevron abrogation bill would purport to solve. So I think that's an argument for the courts addressing the issue, as unlikely as that might seem. But at the end, I think the idea is to encourage Congress through efforts such as a Chevron bill to start thinking about what statutes mean and what language means, and to change the culture internal to the building. And there are ways of doing that that are easy and that are obvious, and would seem to the layperson rather horrifying that they aren't part of the culture already. But staffers writing bills don't consider the Constitution and constitutional limits and current court cases when they are writing language. It's as simple as that. They don't think about them. There is no body within Congress that brings substantive expertise in that way. There is an entity called Legislative Counsel. It is a clerical service, really. You give them an idea and they put it into a proper form, but they are not evaluating limitations on what Congress may or may not do. But I'll leave it at that.
Can I jump in real quick with that? So a more piecemeal approach is what they did in Dodd-Frank with the OCC preemption power, which I think is where they expressly took away Chevron deference. And Kent Barnett's explored this in an NYU article. And I think that's fascinating. If we actually had a Congress that was passing legislation, if they would kind of target and express frustration with how particular agencies are exercising their authority and using it, as Kent would call it, a carrot and a stick, rewarding or taking it away, depending on how the agency's performing. I think that'd be interesting. I think that'd be another kind of interesting solution, instead of a wholesale, have Congress actually start targeting and looking at areas where they feel like agencies have overstepped.
Why don't we open it up to the questions on the floor? Who has a mic? Why don't you catch the person right back there and move forward here for some of the people?
So the bill that you were talking about would establish de novo review for pure questions of statutory interpretation. How would it apply to more applying new facts that maybe Congress hadn't considered at the time, and whether or not they fall within it? Those kind of mixed questions of law and fact. And then on this other end, do you think the ideal system might be closer to what Justice Thomas was talking about, where it's not just the facts that are given deference, not questions of law, but only past and present facts and not future facts applying? Would a system like that, where Congress, the executive branch might be able to say this animal is currently presently endangered, but not be able to set future rules for future facts, would fall within some statute or some prohibition? Would that be an even better system, perhaps, than the current system?
Well, I can say we didn't intend to disrupt the sort of substantial evidence review of fact-finding. The bill would only reach Chevron deference and our deference. And so that is the thinking behind the bill and the conception of the bill. With respect to the other consideration you identify, I think my sense off the top of my head is that would fall into a question of the intent of Congress, whether it, when legislating, meant to capture changing facts or current facts. But that's my initial reaction.
Got some questions down here.
Thank you. Boyd, you forgot when you were in the counsel's office in the White House, when you have nominees come in, you ask them about their adhering to precedent. And that's the first, I think that's one of the first things that's always asked. Are you going to be respectful of precedent as a member of the bench? Today, you're basically saying, take a chance, let's try to, be a little more aggressive. I'm wondering whether or not you're going about solving the problem the right way. It seems to me, and maybe Naomi might want to think about this for another program, but going at solving the Chevron problem the way that we've discussed it, it's not going to happen in the Congress. We've heard that. It's certainly not going to come from the agencies because they have no incentive to do it. The judges, by and large, don't have any authority to do anything based upon how the law has been structured, if they're going to follow precedent. But looking at some of these issues from the regulatory taking side may be a better way of substantively getting at the problem, which is if it begins to impact the dollar, the pocketbook of someone's property, where there may be a better way of going about solving the problem than what we've talked about here today, because I don't hear anything that sounds positive in terms of being able to solve what everybody knows is a problem that now has 30 years basically of architecture around it.
Well, the takings issue is there. It's lurking there, and it's there for the taking, as it were. But the problem, as I see it, maybe it's because of my advanced age, it is sort of a new problem. So precedent that goes back 100 years may not count. When I first came to Washington, as I said, these statutes were far more detailed. Even in the 1990 Clean Air Act amendments, the acid rain title was this cap and trade system. It was a non-regulatory thing. It didn't require any regulations at all. But to go back and look at the provision in the statute, Title IV, each smokestack had a specific tonnage limit in the statute. It wasn't something that EPA it was in the statute. That's how disciplined the Congress was in enacting statute. That doesn't happen now. And so, precedent, the recent precedent, which I was trying to suggest that Justice Scalia had started with American trucking back in 2001, he did the same thing more recently in the EPA case involving new source review, where EPA said, 70,000, 250 tons in the statute really means 70,000 or 90,000 or 150,000. It's quite a stretch for an agency to go from 250 to 100,000 in just a few brief paragraphs. But he said, and I just quote you, he said, when he struck it down in his opinion, quote, "We are not willing to stand on the dock and wave goodbye as the EPA embarks on this multi-year voyage of discovery." Now that's the case that's in law. We heard discussion this morning about the Michigan case, where all 9 judges signed on to looking more closely at cost benefit as a limit, as a limitation on the breadth of delegation. So I don't think, Judge, that this is not following precedent. I think it's taking advantage of the precedent that's out there and expanding on it, and I think it's incumbent upon the judges to do this. But this problem is one of the last 25 to 30 years. It's not a problem of 100 years.
So, Will, I guess I'll direct this question to you because your comments raised, for me, an interesting question is, how much do you think we can solve some of the Chevron hour deference issues with congressional reform? I mean, your point about detailees was striking, One, because you criticized it, but also mentioned that you were on the verge of hiring yet another detailee. So it strikes me that the reason, I don't know, maybe you'll speak to this, but the reason you do that, I assume, is because you and your staff just don't have the expertise necessary to write the statutes or to cover the waterfront. And so, I don't know, is it time for Congress to call for bulking up its staff, whether either for individual members or more professional staff, to make the Office of Legislative Counsel more than a clerical function? If such structural reforms were to go through Congress, how do you think that would have any effect, no effect, an important effect on these Chevron issues?
Yeah, I think wholesale structural reform of Congress would go a long way towards solving some of the theoretical issues that we're discussing. And yes, staffers like me, I think, who, and I'm not sure that there are many, but those that do appreciate some of the complexities associated with bringing a detailee on board, are nonetheless open to doing so for the reason that there is an expertise gap. And if you don't bring on a detail, then you are left at the mercy of the agencies themselves, who who will give you feedback, as we've heard, but will do so in a particular kind of way. And you are at the mercy of other offices on a very competitive hill, as you know. And so, yeah, I think there are a variety of ways of doing this. I don't consider myself an expert in this regard, but if you made the committees, once again, the place where most legislation originated, you could put together a staff there that would have the expertise to produce legislation of the kind that Boyden described, which is quite specific. And there are other ways that are easier of reforming the process. You could consider, and it wouldn't cost that much, a legislative counsel that is actually versed in different areas of the law, capable of giving legal advice that one can identify as true legal advice. And so there are easy, I think, ways of doing this that don't require a great deal of new funding for Congress. But the detail problem is just a manifestation of a body that is not thinking about how it does its own job. And so I would much prefer that Congress not look to the executive branch to solve its institutional failures. As it is, that's how it's done. But there are easy ways, I think, of shifting away from that, and they don't necessarily involve additional funding or a different kind of staffer.
Can we go to the other side of the room here, in the front here?
I was wondering, do you think Chevron reduces the number of circuit splits, and was that something you looked at in your study, Mr. Walker?
I mean, we didn't look at that in the study, but you wouldn't have a circuit split over that substantive question. Right? There is definitely the uniformity of law argument for Chevron. And I go back and forth on that because the flip side is, like, I'm thinking of when the court. I think for the Supreme Court, that Chevron is a great tool to control lower courts, because it displaces power away from the lower court towards the agency. And yet if the Supreme Court doesn't agree with the agency, we know they don't usually apply Chevron. And so they kind of get the benefit of Chevron controlling lower courts and avoiding those issues. And when it does percolate up, they can still review de novo, as Bill Eskridge would argue in his paper. And so I think that's kind of a weird feature, but like I'm not as sure though it's a virtue that circuit splits aren't coming up on important issues because courts are applying deference. I guess I kind of push back on that as a virtue, but that's definitely one of kind of the bedrock, at least academic responses for why we left Chevron, is that it allows for more uniformity in federal law.
I think we're almost out of time. Can we do another question? Yeah. Okay, so we'll do one more question. Two. Okay, so we'll hit Jimmy and then John, and then we'll be done.
So one of the principles of statutory interpretation that gets neglected a lot when we're talking about Chevron is, I think, the rule of validity. And I think this gets to Ashley's question to the panel, which is, we have a principle of interpretation that says in a statute that has criminal consequences, we are just going to say no when the agency tries to expand its authority. And almost every administrative scheme I can think of has criminal consequences, and most regulations have criminal consequences. So wouldn't that be a useful way to cabin Chevron, at least semi-broadly? And I think there's a couple of opinions by Judge Sutton that get to this point.
Any comments from the panel?
Well, I think that's a good point, right? I mean, a lot of regulatory schemes do have criminal penalties, and so you think the rule of lenity might apply. But there's definitely been a whole literature arguing also why the rule of lenity just shouldn't apply at all in the administrative state, because we now have a kind of expectation of regulation. I don't necessarily agree with that body of literature, but it's certainly an argument that a number of people have made.
Just to add, I mean, not just the rule of lenity, but like any substantive canon, right? I mean, if you wanted to be aggressive on that, and I've written to the contrary, so I probably won't be, but you know, constitutional avoidance, federalism canons, presumption against preemption, you could apply those all as a step 0 inquiry, or even a step 1, you know, a really strong step 1 inquiry, and cut back significantly on the role of agencies. I personally don't think that's the right way to go for a number of different reasons, but that is one way to address Chevron.
Can we get Jonathan, and then if you can keep it short, Jonathan, we'll wrap it up.
Yeah, so super quick. In King versus Burwell, the Chief Justice notes that the ACA had a particularly unorthodox legislative history. And so my question is, how should that cut? If, apart from what goes on in committee versus not committee, but in an extreme case where there's no House Senate conference, there's none of the usual drafting and editing and revising of a statute, is that something courts should care about, or should bicameralism and presentment simply be an indication that the legislature did what it did, it doesn't matter how they did it, it satisfied constitutional requirements, we take all legislation as they come the same way?
So if I were applying the approach in the paper, it would matter a lot, because I would consider that part of a purposes inquiry under Skidmore. In other words, the agency would then have the burden to step forward and say, this is our expertise. We were at the drafting table. This is what was decided. This is what wasn't. And so in an unorthodox lawmaking situation where there is no record, and they wouldn't be able to have that type of evidence. So by definition, the Skidmore weight would be less than in a situation that's more normal, where you see a legislative process work and you see the agency there. But I don't know. I mean, what do you do otherwise, right? I mean, if it's just a complete black box. I do hope with my paper you see a lot of it is a black box. You know, technical draft assistance almost always happens on a confidential basis. You don't know those inputs from the agency at the other end.
Okay, well, let me thank everybody in the audience for attending the panel, and could you all join me in thanking the panelists for excellent discussion.